Good morning, everyone. Thanks for coming. We had our court appearance today. As you saw, we submitted our response to the Fry hearing, the motion to preclude some of the DNA analysis and results related to the DNA analysis performed on the hair. So we've provided our response to that. Previously, the defense made a motion to sever the various counts in the indictment. We anticipate objecting to that motion, and we're going to file our objection to that motion on February 18th. Also today, defense counsel provided us with a letter of materials that he believes he has not received. We just received that. We believe he's received all the relevant material in the case, but we're going to recheck that with our expert, and we're going to meet with defense counsel at some point next week to go through that letter that he just served upon us, and then at that next date, February 18th, both parties will be in a better position to talk about what, if any, discovery is outstanding. So that's basically it. If I could just ask my colleague, where is Nick? So, could you have Nick just give me the discovery that we provided thus far? And so that's it. So does anybody have any questions?
About how long, once the judge sets the Fry hearing date, how many days do you think that would take?
Well, it varies. I mean, I think, we're going to have a number of experts testify. I would anticipate the defense having an expert or experts testify. So, and I think it's highly dependent on how the hearing goes. So it will, this judge likes to move things along expeditiously, so he's been pushing us, he's going to continue to push us. So this is, complex scientific evidence, so it's going to be, a substantial hearing, but we'll just have to sort of wait to see how
Several days.
It'll be more than a day, I would say, certainly.
Do you have any word on any start dates of the trial, overall trial?
So, I mean, now we've got the DNA, we've got the motion to sever. So we're now we're beginning motion practice. So this is the next step, but we have to complete the next step. And so that question would have me speculate as to how motion practice goes, and I can't do that. I won't do that, and I can't do that. So it depends. I will say that if you look at cases of this nature, thank you. If you look at cases of this nature, seven alleged murders happening between 1993 and 2010. If you look at similar cases, these are substantial, weighty legal issues, and it takes time.
So obviously none of us were allowed back in that conference, but based on what we did see, it sounds like the defense delivered to you a demand letter this morning that asked for evidence that you argued in that conference he has the majority of it, if not all of it. Was there any frustration on the part of the judge or on the part of the prosecution with this latest stall, basically, on the beginning of this trial?
Well, I think the judge, I think the judge is pushing both sides, as I've said, continually through the course of the case, and that's what the judge is going to do. That's the judge's role, and this is the nature of the business. This is the business that I don't think that the media or the public necessarily sees. The discovery process, and that's why globally, we're asking our legislature and our governor to take a look at discovery and try to do something to help us, because obviously these are it's difficult, it's onerous, and we're trying to comply. The position of the defense is that they've spoken to experts, and they claim that they haven't received stuff, and that they're entitled to more materials. So that's their position. This is that's what happens in these cases. it's not a matter of being frustrated or not being frustrated, being happy or being sad. Doesn't matter. Doesn't matter what I think. Doesn't matter how I feel. We move the case forward. We'll talk to our experts. We'll see what we can agree on in the letter. Whatever we can agree on, we will. Whatever we say we've already provided, we'll indicate that. And if we have a disagreement, we'll come back on the 18th to the court and we'll make our argument.
This is the major delay, though, for this trial is the discovery process.
Well, I mean, what we're doing now is we're talking about the admissibility of the DNA evidence, a portion of the DNA evidence, which has never been litigated in New York State before. So, again, the process by which we get there, this is typical in a case. So, I'm not at all, surprised to be litigating this issue as well as side issues off of the main Fry issue.
And as far as severing the case, does your office want to try them all as one, or what is your position on severing?
So, yeah, we're going to oppose. If you look at the evidence, all of the evidence is, it is properly joined, and we'll make those arguments. And I think if you look at intent, what was the intent? What was the alleged intent of this individual on some of the evidence that we have in this case? I think the alleged intent of the evidence was clear with regard to all 7 charged crimes.
What are some of the items in the demand letter that they're alleging were?
Well, I mean, we just received it. I think a lot of it has to do with various entities that are involved in it, but with and various labs. But I think it's a question of if you have Astria working at a particular college, it has all that material included. The defense wants to make sure all the material is included. We'll check. If you look at the discovery in this guy, I have 4 pages of the discovery that we provided. So the discovery that we've provided is voluminous, but if there's something that needs to be provided in addition to that, we certainly will do that.
DA Tierney, your office has started a new cold case unit. I believe there are up to 300 unsolved cases on Long Island or in Suffolk County. Your website put out 5 new victim does last week. At least that's when we saw it. Are any of these victim does possibly tied to Rex Heuermann? Some of the scenarios look like maybe there are some elements there that would match his MO.
I think you know what I'm going to say to that. I think that the way we've been able to have success, to the extent that we've been successful, that success stems from our approach, and our approach first and foremost is to use a task force model, work with our partners, and to look at each crime scene, each area where a body has been discarded and left, and treat that as an individual, separate, distinct case, and work all the evidence that proceeds out from that crime scene until we have a reason to treat it otherwise. So that's what we're going to do. We don't make any assumptions. We don't say we think this. It doesn't matter what I think. Or what my investigators or what my partners or my ADAs, what they think, what we think, what doesn't matter. What we need to do is we need to figure out what we can prove. And if we can prove something and take it to the grand jury and it results in charges, we'll talk about it. But as of right now, there are 7 alleged crimes committed by this defendant, and that's what our position is with regard to his involvement.
DA Tierney, can you talk about some of the challenges or potential challenges in presenting DNA technology that, as you said, has never been used here in New York before?
Yeah, I think it's challenging. I think it's exciting. I think this is the next generation of DNA testing. I started in 1992. We had RFLP, then we went to PCR, then we went to STR. Now I would submit that this is the next generation of the evolution of the technology. It's exciting to be at the forefront of that, and we look forward to proving the scientific acceptance and the effectiveness of this technology. And again, we say new technology. It's not new technology. It's used in all of our everyday lives. It's used in medical, forensic, paleontology, identifying war dead, identifying 9/11 remains, all of these things. So we're just applying this, I submit, we're applying this very effective and tried and true technology to the courtroom. So I want to say that back in 1995 or 1996, I participated in a trial which was the first use of SDR. I don't know if it was in New York State, certainly in Suffolk County, and back in 1995, SDR was the novel. So again, technology evolves, as we all know, and it's exciting to be a part of that.
So this is the first time that somebody is fighting this new technology for DNA, or you said something about this as the first?
Yeah, well, I think the whether you call it SNP testing or WGS, whole genome sequencing, this is a technology, and this is the first time the SNP testing, utilizing the WGS format, is being litigated in New York State. Now, it's been if you look at our reply, we talk about other jurisdictions where it has been deemed admissible. So it has been deemed admissible in other parts of the country. So we're just going to now submit that it should be utilized in New York State.
Should the motion to sever be granted, does that present any unique challenges?
Well, I'm not going to talk about perspective. We believe it was properly joined. We believe that we have good grounds to oppose it. We're going to, submit those grounds, and we'll let the court decide. But we believe that the case is properly joined, and we're going to certainly argue that point in front of the judge. The judge will make his decision, and we'll deal with it at that point.
DA Tierney, the Bishop case was prosecuted by a previous district attorney, but now you're in charge, and you know that there are motions that have been put in regarding DNA testing that was redone with new technology, and there was DNA discovered on the pants found at Colleen McNamee's crime scene. Do you think there's anything that is turned up in this new testing that would compromise Bittroff's conviction?
So if I thought that I had seen something that would make me question the validity of that case, I would take the necessary steps. I will say that with regard to that, we've received the motion. We've received I believe it was an 8-page report, and that's what we've received. And this is what we've provided to the defense with regard to our DNA testing in our case. With regard to that matter, we've received that 8-page report. So, just as the defense, when provided with scientific evidence, they have to do their due diligence and look at it. We have to do our due diligence in that case, and hopefully we'll get the same degree of discovery that is expected of us.
Just want to check, were motions filed about the DNA today, or that's just an ongoing discussion?
I'm sorry. Yeah. So previously, the defense filed their motion to preclude the hair analysis of the hairs in this case, and today we submitted our response to that motion. And in our response, they're asking for preclusion of the evidence, or in the alternative, a Frye hearing. And we submitted that the technology that we're using is accepted in the scientific community. It was properly done, therefore it should be admissible. However, we recognize that this is an issue of first impression in New York State courts, so we consented to that Frye hearing to have the court make that determination for itself.
Could there be any more indictments before trial?
We're going to continue to work, and we'll let the indictment speak for itself if and when we get an indictment in this or any other case. But we are, as an office, we are looking at so many different things. We have the cold case. We're looking at a number of different matters, but until any of those cases result in an indictment as to any individual, we're just not going to talk about it. Because I think when you talk about cases, you talk about uncharged cases, that's when prosecutors get themselves in trouble. And prosecutors should speak through indictments. Prosecutors should not speak through supposition, I think this, and because it doesn't matter. It just doesn't matter. So we're going to continue to speak through our indictments. Is that it?
Thank you.
Okay, thank you very much.
Thank you.